In the early days of the internet, tech companies grew with very few rules. Like children playing in a big open field, they could run freely in any direction. Companies like Google, Facebook, and Amazon started small but grew into giants that touched almost every part of people's lives. The story begins in the 1990s. Back then, lawmakers saw the internet as a new frontier that needed freedom to grow. In 1996, the United States passed the Communications Decency Act, which included Section 230. This important law protected websites from being responsible for what users posted. This protection helped social media companies grow without fear. As these companies got bigger, they collected more and more information about people. They knew what people searched for, what they bought, and who they talked to online. By the early 2000s, Google wasn't just a search engine anymore. It became the gateway to the internet for billions of people. Facebook, which started in 2004 as a simple way for college students to connect, soon had millions of users sharing personal details every day. Amazon moved from selling books to selling almost everything and knowing exactly what each customer liked to buy. The power of these companies grew faster than laws could keep up. By 2010, smartphones put the internet in everyone's pocket. Apps tracked where people went and what they did all day. The tech companies knew more about people than any businesses in history. People began to worry. In Europe, concerns about privacy led to new rules. European lawmakers believed that personal information belonged to the people, not to companies. In 2016, they created the General Data Protection Regulation, GDPR, which gave people more control over their information. Meanwhile, in the United States, the approach was different. Instead of making strong new laws, the government mostly let tech companies run themselves. The Federal Trade Commission, FTC, sometimes stepped in when companies broke promises to users, but big tech mostly set its own rules. This difference between Europe and America created problems for the companies. They had to follow different rules in different places. Some built separate systems for European users versus American users. By 2018, more concerns appeared. Tech platforms became places where false information spread quickly. Some worried that foreign countries could use these platforms to affect elections. Others worried that a few big companies had too much control over what people saw and read online. The tech giants responded by hiring more people to work with governments. They opened offices in Washington, Brussels, and other capitals. They spent millions of dollars talking to lawmakers, trying to shape any new rules that might come. Small problems grew into big ones. In 2018, news broke that a company called Cambridge Analytica had taken information from millions of Facebook users without clear permission. This shocked many people and made them realize how much of their information was out there. Lawmakers began calling tech leaders to explain themselves. The friendly relationship between Silicon Valley and government started to change. Tech leaders who were once seen as brilliant inventors were now questioned as powerful businesspeople who needed oversight. By 2020, the calls for new rules grew louder. Different countries developed different approaches. Some focused on privacy, others on competition, and others on harmful content. Tech companies faced a growing maze of laws and regulations around the world. The days of the open field were ending. The tech giants now found themselves in a world with more fences, more rules, and more people watching what they did. The question was no longer if there would be rules, but what those rules would be. The storm had been brewing for years, but in 2019, it finally broke. Government officials in the United States, Europe, and elsewhere started formal investigations into the biggest tech companies. They asked a simple but powerful question: had these companies grown too big? It began when leaders at the Federal Trade Commission, FTC, and Department of Justice, DOJ, divided up the tech giants for investigation. The FTC would look at Facebook and Amazon. The DOJ would handle Google and Apple. This division showed how serious they were. The concerns were not new. For years, smaller companies had complained that the tech giants were playing unfairly. App developers said Apple took too much money from their sales. Small businesses said Amazon competed against them while controlling the marketplace they sold in. Website owners said Google pushed people to its own services instead of theirs. What made these investigations different was their size and scope. These weren't small cases about specific problems. They questioned the basic way these companies operated and had grown so large. In October 2020, the Department of Justice filed a major lawsuit against Google. They claimed Google paid billions of dollars to companies like Apple to make Google the default search engine on phones and browsers. This, they said, made it almost impossible for other search engines to compete. It was the biggest antitrust case since the government sued Microsoft in the 1990s. The FTC followed with a lawsuit against Facebook in December 2020. They claimed Facebook had bought Instagram and WhatsApp to remove competition. The message was clear: buying competitors to stop competition wasn't allowed. In Europe, similar actions had started earlier. The European Commission, led by Margrethe Vestager, had already fined Google 3 times for different violations of competition law, totaling over $9 billion. They fined Google for favoring its own shopping service in search results, for rules it placed on Android phone makers, and for blocking competitors in online advertising. Behind the scenes, investigators demanded thousands of documents from the companies. They interviewed hundreds of people who had worked at the tech giants or competed with them. They read emails from years ago, looking for evidence that company leaders had tried to hurt competition. The tech companies fought back hard. They'd hired top lawyers and spent millions on defense. They'd argued that they had succeeded by making good products people chose to use, not by breaking laws. They said breaking up their companies would hurt users and make products worse. The investigation spread to more countries. Australia pushed for rules forcing Google and Facebook to pay news organizations for their content. India looked at Amazon's treatment of local sellers. China began its own crackdown on tech giants like Alibaba and Tencent. Small rivals found their voice. Spotify complained about Apple's App Store rules. Yelp said Google copied its reviews and favored its own local listings. News publishers said Facebook and Google took their advertising money while using their content. The companies faced tough questions in public hearings. Lawmakers showed emails where executives discussed buying competitors to stop them from threatening their business. Some emails showed company leaders worried about competition that later disappeared after being purchased. Tech executives found themselves in uncomfortable positions. They had to explain complex business decisions to legislators who didn't always understand technology but did understand power. The friendly image these companies had built over years began to crack. The cases moved slowly through courts, as big legal battles often do. But one thing became clear: the era of light regulation for big tech was ending. Whether these investigations would lead to breaking up companies, changing their business models, or just fining them remained to be seen. For the first time since they grew into giants, these tech companies faced the real possibility of government action that could fundamentally change how they operated. The balance of power had begun to shift. In early 2018, the world watched in shock as news broke about what would become the defining privacy scandal of the decade. Facebook users discovered that a company called Cambridge Analytica had collected data from up to 87 million profiles without clear consent. This information had been used to target political messages during major elections. The revelation hit like a thunderbolt, forcing ordinary people to confront a troubling question: who really controlled their personal information? Mark Zuckerberg, Facebook's founder, found himself called to testify before Congress. Lawmakers who barely understood social media grilled him for hours about data practices. The hearing was watched by millions. For many people, this was the moment they realized how much of their personal information was being collected, shared, and used without their knowledge. Across the ocean, European officials had seen this coming. They had spent years developing the world's strongest privacy law, the General Data Protection Regulation, GDPR. When it took effect in May 2018, just weeks after the Cambridge Analytica scandal, companies worldwide scrambled to comply. The GDPR gave people new rights: the right to see what data companies had about them, the right to correct mistakes, and even the right to be forgotten by having data deleted. Companies had to clearly explain what information they collected and why. Breaking these rules could bring huge fines, up to 4% of a company's global income. The effect was immediate and visible. Websites put up cookie notices. Apps asked for permission before tracking location. Email inboxes filled with updated privacy policies. Behind the scenes, companies rushed to organize their data and build systems to handle user requests. California, home to many tech companies, didn't wait for the U.S. federal government to act. In June 2018, it passed its own privacy law, the California Consumer Privacy Act, CCPA. While not as strong as the GDPR, it gave Americans their first serious data protection rights. Other states began working on similar laws. Tech companies faced a difficult adjustment. Their business models relied on collecting as much data as possible to target advertisements. Now they had to balance this against new legal requirements and growing public concern. Google received a €50 million fine from French authorities in 2019 for not properly disclosing how they use personal data. This was just the beginning. The spotlight on privacy revealed uncomfortable truths. People learned that their phones tracked their movements. Smart speakers recorded conversations. Dating apps knew intimate details. Shopping sites remembered everything they looked at. Digital assistants knew what questions they asked. And all this information could be combined to create detailed profiles of their lives. New privacy problems emerged regularly. In 2019, people discovered that contractors listened to recordings from smart speakers like Amazon's Alexa and Google Home to improve voice recognition. The same year, FaceApp went viral for turning photos into older versions of people's faces, before users realized the app was sending their face data to servers in Russia. Tech companies responded by highlighting privacy features. Apple made privacy a major selling point, limiting how apps could track users. Google added options to automatically delete location and search history. Facebook promised a privacy-focused vision with more private messaging and less permanent content. Behind these public moves, a deeper change was happening. Data, once collected freely and kept forever, now came with legal responsibilities and business risks. Companies had to consider privacy from the beginning when building new products, not as an afterthought. For ordinary people, the situation remained confusing. Privacy policies were still long and difficult to understand. Settings to control data were buried in menus. Different laws in different countries meant protection depended on where someone lived. By 2020, privacy had moved from a technical issue to a mainstream concern. People began to understand that their digital lives created valuable information that companies collected and used. The question was no longer whether personal data should be protected, but how strong the protection should be and who should enforce it. The grand marble halls of Congress had seen many powerful people over the years, but the sight of four tech CEOs appearing together on video screens in July 2020 marked a new chapter in American business history. Jeff Bezos of Amazon, Tim Cook of Apple, Mark Zuckerberg of Facebook, and Sundar Pichai of Google sat in their separate offices, ready to face hours of tough questions from lawmakers. The hearing came after a year-long investigation into whether these companies had too much power. Each CEO tried to appear humble while defending their business. Zuckerberg reminded lawmakers that Facebook started in his college dorm room. Bezos spoke about his mother having him when she was just 17 years old. Behind these personal stories was a clear message. These were American success stories, not dangerous monopolies. But lawmakers came prepared with specific examples of troubling behavior. They showed internal emails where executives discussed buying competitors to eliminate threats. They quoted complaints from small businesses that felt crushed by the giants. Both Republicans and Democrats asked hard questions, though they often focused on different concerns. Republicans worried about alleged bias against conservative views, while Democrats focused more on market power and competition. The virtual hearing format created awkward moments. Bezos forgot to unmute himself before speaking. Technical problems interrupted questions. Yet despite these issues, the message was clear. Tech companies were no longer seen as innovative heroes, but as powerful corporations that needed oversight. Just 3 months later, in October 2020, another significant court appearance took place. This time, the Justice Department formally sued Google, accusing it of illegal monopoly practices in search and advertising. Attorney General William Barr called the case monumental, comparing it to the breakup of AT&T in the 1980s. Google's response was swift and direct. They called the lawsuit deeply flawed and said people used Google because they chose to, not because they were forced to. These high-profile appearances reflected a dramatic shift. For years, tech executives had been welcome guests in Washington, invited to share their innovation and vision. Now they were being summoned to defend their business practices under oath. The European Union had already set this tone years earlier. In 2017, Margrethe Vestager, the EU's competition chief, announced a record €2.4 billion fine against Google for favoring its own shopping service in search results. In a Brussels press room, she delivered her verdict with calm determination. Google has abused its market dominance as a search engine by promoting its own comparison shopping service in its search results and demoting those of competitors. Google disagreed strongly and appealed the decision. Behind closed doors, tech companies prepared extensively for these appearances. They hired former government officials who understood the system. They practiced answers to likely questions. They prepared data and examples to defend their positions. Despite this preparation, executives often appeared uncomfortable when pressed on specific details of their business practices. The court appearances extended beyond antitrust issues. In November 2020, Zuckerberg and Jack Dorsey of Twitter appeared virtually before the Senate Judiciary Committee to answer questions about content moderation and the 2020 election. Senators pressed them on how they handled controversial posts, with both Republicans and Democrats unhappy for different reasons. These hearings revealed the complex relationship between tech companies and government. The companies wanted to appear cooperative while protecting their business models. Government officials wanted to show they were tough on big corporations while also recognizing the importance of the tech industry to the economy. For the public watching these appearances, they offered a rare glimpse into how power worked in the digital age. The hearings pulled back the curtain on how decisions affecting billions of users were made. They showed that behind friendly apps and services were powerful companies fighting hard to maintain their position. The era of tech companies avoiding serious government scrutiny had ended. The question was no longer if there would be oversight, but what form it would take and how tech companies would adapt to this new reality. The year 2021 marked a turning point in the battle between governments and tech giants. After years of investigations and court proceedings, major decisions began to reshape the digital landscape. These rulings and settlements hit not only company policies but also their bank accounts. In June 2021, a French competition authority delivered a shocking blow to Google. It fined the search giant €220 million, $268 million, for abusing its power in the online advertising market. What made this case special was that Google didn't fight it. They accepted the findings and agreed to change how their advertising technology worked worldwide. This rare surrender showed that even Google recognized some practices couldn't be defended anymore. Just 1 month later, Amazon faced its own reckoning in Luxembourg. The European Union's privacy watchdog fined Amazon a record €746 million, $887 million, for breaking the GDPR privacy law. This was the largest privacy fine in history, far bigger than anything that came before. The message was clear. Even the world's most valuable companies had to follow the rules about personal data. Back in the United States, Facebook, now Meta, found itself on the losing end of a major legal battle. In 2021, the Federal Trade Commission refiled an antitrust lawsuit that sought to force Facebook to sell Instagram and WhatsApp. Judge James Boasberg, who had dismissed an earlier version of the case, now allowed it to move forward. His 53-page opinion stated that the FTC had provided enough evidence that Facebook might have built a social networking monopoly. The company's stock dropped by 4% on the news, wiping out billions in market value. Epic Games, the maker of the popular game Fortnite, scored a partial victory against Apple in September 2021. Judge Yvonne Gonzalez-Rogers ruled that Apple could no longer prevent app developers from directing users to payment options outside the App Store. Though Epic lost on most of its claims, this single ruling threatened Apple's control over its highly profitable app ecosystem. The change could cost Apple billions in lost revenue as developers avoided its 30% commission. Not all cases went against the tech companies. In June 2021, a judge dismissed antitrust complaints against Facebook filed by multiple states. The judge said the states had waited too long to challenge Facebook's acquisitions of Instagram and WhatsApp, which had happened years earlier. This showed that timing and legal strategy mattered as much as the underlying facts. The world watched closely when, in November 2021, the United Kingdom's Supreme Court blocked a $14 billion class action lawsuit against Google over alleged illegal tracking of millions of iPhone users. The court ruled that the claimant failed to prove users suffered actual damage. This case showed the difficulty of winning large compensation for privacy violations, even when the underlying practices seemed questionable. Beyond court rulings, settlements became a common way to resolve cases without the uncertainty of trials. In 2021, Facebook agreed to pay $650 million to settle a lawsuit in Illinois over its facial recognition technology. TikTok paid $92 million in a similar case. These settlements allowed companies to move forward without admitting wrongdoing while still compensating users. The largest settlement came when Google agreed to pay $270 million to French publishers for using their news content. This agreement followed a new French law requiring payment for news snippets. Similar battles played out in Australia, where both Google and Facebook eventually agreed to pay news organizations after an intense standoff that briefly led Facebook to block news content on its platform. These rulings and settlements did more than just impose fines or force changes. They established new boundaries for what tech companies could do. They created precedents that would guide future cases. Most importantly, they shifted power away from the companies and toward regulators and users. For ordinary people, the impact was gradual but real. Apps asked for permission before tracking. News sites received payment for their work. Advertisers gained more choices. The digital world didn't transform overnight, but the foundation for a different relationship between tech companies and society was being built, one ruling at a time. The global internet had once promised a world without digital borders, but by 2022, that dream was fading fast. As different regions created their own rules for technology companies, the internet began to splinter into distinct regulatory zones. Tech giants found themselves playing by different rulebooks depending on which country they operated in. The European Union stood at the forefront of tech regulation with an approach built on strong central rules and hefty penalties. In April 2022, EU lawmakers reached a historic agreement on the Digital Services Act, DSA, and Digital Markets Act, DMA. These twin laws imposed strict new obligations on large platforms. The DSA required companies to quickly remove illegal content and explain how their recommendation algorithms worked. The DMA prevented tech giants from giving preference to their own services and restricted how they could use data collected from business users. Thierry Breton, the EU commissioner overseeing digital policy, proudly declared, "The time of big online platforms behaving like they are too big to care is coming to an end." With fines up to 6% of global revenue for DSA violations and 10% for DMA breaches, the EU had created the world's strongest tech regulations. Meanwhile, China took an entirely different approach. The Chinese government viewed tech regulation as a matter of national security and social stability. In late 2020, Chinese authorities suddenly halted the $37 billion IPO of Ant Group, Jack Ma's fintech giant, signaling a new era of strict control. Throughout 2021, the government launched investigations into tech companies, forced app removals, and imposed new data security laws. Chinese tech companies found themselves caught in a vice. The government demanded they control content, protect national security, and promote positive energy while still innovating and growing the economy. Companies like Tencent, Alibaba, and ByteDance, owner of TikTok, had to dedicate massive resources to compliance, creating special teams to work directly with government officials. The United States took a third path, characterized by debate without comprehensive action. While the EU created broad new rules and China exerted direct control, the US approach remained fragmented. Lawmakers introduced multiple bills targeting tech companies but struggled to build consensus. The American Innovation and Choice Online Act, which would have prevented platforms from favoring their own products, gained bipartisan support but faced intense lobbying from tech companies. Without federal legislation, U.S. regulation developed through a patchwork of state laws, court decisions, and actions by agencies like the Federal Trade Commission. California implemented privacy laws, Texas passed rules about social media content moderation, and Colorado created its own data protection framework. This piecemeal approach created compliance headaches for companies operating nationwide. Other regions developed their own distinct approaches. India required tech companies to store certain data locally and gave the government power to demand message traceability, challenging the encryption used by WhatsApp and Signal. Brazil passed the Marco Civil da Internet, establishing strong net neutrality and privacy protections. Australia required platforms to pay news publishers and threatened executives with jail time for failing to remove harmful content quickly enough. For the tech giants, this global divergence created enormous complexity. A social media post that was required to be removed in Germany might be protected speech in the United States. Data that could be freely processed in Brazil might require explicit consent in Europe. Content moderation teams needed different rules for different countries. Companies responded by regionalizing their operations. They built data centers in countries with local storage requirements. They created country-specific versions of their services with different features and policies. They hired experts in regional regulations and established government relations offices around the world. The cost of compliance soared. One study estimated that complying with the GDPR alone cost companies more than $9 billion annually. Facebook, Google, Apple, and Microsoft each employed hundreds of people focused solely on regulatory compliance. For Internet users, the experience began to differ depending on where they lived. Europeans saw more cookie consent notices and had stronger privacy rights. Chinese users accessed a heavily monitored internet with local alternatives to Western services. Americans had fewer privacy protections but more content freedom. The vision of a single global internet was giving way to a world of regulatory regions, each with its own rules, requirements, and digital boundaries. When the pressure became too great to ignore, the tech giants began to change. Like massive ships slowly turning in rough seas, these companies adjusted course in response to legal challenges, public criticism, and the threat of stronger regulation. Their transformations weren't always willing, but they were significant. Meta, the company formerly known as Facebook, undertook perhaps the most visible makeover. In October 2021, Mark Zuckerberg announced not just a new name but a new direction, shifting focus to the metaverse. Behind this futuristic vision was a practical reality. Facebook's core social media business faced serious regulatory threats. The company also created an independent oversight board with power to overturn content decisions, even those made by Zuckerberg himself. Critics called these changes superficial, but they represented an unprecedented limit on a founder's absolute control. Apple positioned itself as the privacy champion among the tech giants. In 2021, the company rolled out app tracking transparency, requiring apps to get permission before tracking users across other apps and websites. This single change disrupted the entire mobile advertising industry and cost companies like Meta billions in revenue. Apple's CEO Tim Cook made privacy a central message. At Apple, we believe privacy is a fundamental human right. This stance helped Apple appear more responsible while also hurting competitors who relied heavily on targeted advertising. Google took a different approach, making technical changes while fighting larger structural reforms. The company announced it would phase out third-party cookies in its Chrome browser, a move that would reshape online advertising. At the same time, Google reorganized its businesses to separate its advertising technology operations, making them easier to defend or potentially sell off if required by courts. Behind the scenes, Google developed privacy sandbox technologies that aimed to preserve targeted advertising while offering more privacy. Amazon responded to scrutiny by adjusting some business practices while vigorously defending others. The company ended certain controversial practices like requiring price parity, preventing sellers from offering lower prices elsewhere, and using seller data to develop competing products. However, Amazon fought fiercely against more fundamental changes to its business model, particularly efforts to limit its ability to promote its own products alongside third-party sellers. Microsoft managed to largely avoid the harshest regulatory spotlight despite its massive size. The company had learned valuable lessons from its own antitrust battles in the 1990s. Under CEO Satya Nadella, Microsoft strategically supported many regulatory efforts targeting its rivals. The company publicly backed Australia's news payment law and called for greater platform responsibility, positioning itself as the adult in the room while competitors faced harsher treatment. Beyond public-facing changes, tech companies transformed internally. They hired armies of lawyers, policy experts, and former government officials. Facebook, Google, Amazon, and Apple each spent over $20 million annually on lobbying. They created dedicated compliance teams to track regulatory requirements across dozens of countries. Board meetings now regularly included discussions of regulatory risks alongside traditional business concerns. Some reforms went deeper, affecting how products were built and decisions made. Many companies adopted privacy by design principles, considering data protection from the earliest stages of product development rather than as an afterthought. Trust and safety teams grew from small groups to major departments with thousands of employees. Ethical AI committees reviewed algorithms for potential bias or harmful effects before deployment. The mindset within these companies evolved too. The move fast and break things ethos that defined early Silicon Valley gave way to more cautious approaches. Employees at all levels became more aware of compliance requirements and potential risks. The question, "Is this legal?" began to accompany the traditional question, "Is this possible?" These changes came with real costs. Product launches slowed. Innovation became more careful. Companies spent billions on compliance that could have gone to research or new features. Some argued this caution was necessary and overdue. Others worried that excessive regulation would lock in the dominance of existing giants who could afford to comply while preventing new competitors from emerging. What was clear was that the era of tech companies operating with minimal oversight had ended. Whether through sincere reform or strategic adaptation, the giants of Silicon Valley had begun to accept that their industry's special status was over. They were now regulated corporations, not exception-seeking disruptors. By early 2023, the relationship between technology companies, governments, and users had reached a new equilibrium. The Wild West days of the early internet were firmly in the past. A more regulated, more cautious tech industry had emerged from years of battles, but important questions remained unanswered about who would ultimately shape the digital future. Government regulators around the world had scored significant victories. The European Union's Digital Markets Act forced major platforms to open their systems to competitors. Apple reluctantly allowed alternative app stores on iPhones in Europe, ending years of complete control. Google made search results more neutral after repeated fines. Amazon adjusted how it treated third-party sellers. These weren't total transformations, but they marked real limits on previously unchecked corporate power. Users found themselves with more rights but continued challenges. Privacy notices became common, but many people clicked accept without reading. Data protection laws gave people theoretical control over personal information, but exercising these rights required time and knowledge that most lacked. Content moderation improved but remained inconsistent across platforms and countries. The digital experience became safer in some ways, but also more complicated and fragmented. The debate about breaking up the biggest tech companies remained unresolved. In the United States, the Federal Trade Commission's case against Meta for buying Instagram and WhatsApp continued through courts. The Department of Justice pushed forward with its case against Google's search dominance. But even as these landmark cases proceeded, the tech giants grew larger and more integrated, making potential breakups increasingly difficult to implement. New battlegrounds emerged beyond the original fights over competition, privacy, and content. Artificial intelligence became a central concern as AI systems grew more powerful and widespread. Governments worried about bias, misinformation, and job displacement. The tech companies pushed for self-regulation while investing billions in AI development, setting up another clash between innovation and oversight. The cryptocurrency industry faced its own regulatory reckoning after several major collapses highlighted risks to consumers. Central banks developed digital currencies to compete with private coins. The finance and tech worlds increasingly overlapped, creating complex questions about who should regulate digital money. National security concerns added another layer of complexity. The United States restricted Chinese companies like Huawei and TikTok over fears about data security and foreign influence. China implemented tough data security laws limiting how foreign companies operated there. Technology regulation became intertwined with geopolitics, with countries treating digital sovereignty as a matter of national importance. Smaller countries found creative ways to influence the global tech ecosystem despite limited resources. Ireland used its position as the European headquarters for many tech companies to shape enforcement of EU rules. Singapore developed specialized technology courts to handle complex digital cases. Kenya pioneered mobile money regulations that influenced approaches in other developing nations. For ordinary people, the most visible change was greater awareness. Users became more conscious of how their data was used, how content was moderated, and how digital markets worked. This awareness didn't always translate to power, but it changed the relationship between people and platforms. Companies could no longer assume user trust or ignore public concerns. The tech industry itself divided into different camps. Some companies embraced regulation as inevitable and tried to shape it. Others resisted fiercely. Newer tech firms watched carefully, learning from the mistakes of their predecessors and building businesses designed to withstand regulatory scrutiny from the start. What emerged wasn't a clear victory for either side, but a new, more balanced relationship. Technology companies remained enormously powerful but operated within clearer boundaries. Governments gained meaningful oversight but struggled to keep pace with innovation. Users gained important protections but still faced an online world designed primarily for commercial interests. The story wasn't over. The balance would continue to shift as technologies evolved. New challenges emerged, and different approaches competed for dominance. But one thing was certain: the future of technology would be shaped not just by brilliant engineers and entrepreneurs, but by lawmakers, judges, regulators, and ultimately by the choices of billions of everyday users around the world.